According to my computer, I'm wondering if we have the applicant is here.
It's muted. I see them in the participants list, but maybe they could just pop on so we know they're here.
I'm sorry, are you asking if the applicant's here? Because we are.
Thank you. Yes.
Okay. And we have Phil, is that correct? Just no video for Phil?
I see his name in the list, but maybe Phil could give us a verbal when he is here.
I didn't hear anything. Phil, did you unmute your audio and let us know you're here?
I'm in, Phil.
And so down here in the lower left, where it says mute,
No.
that's what it was. That little message was they were telling you to take your microphone out. So now if we start video,
Okay.
we'll fix that. So you see that little line across video? That's telling them you're not showing the face. Now you're going to show your face.
Okay.
And there I am. But there you are.
Thank you, lady.
You are welcome. Have a good meeting.
Thank you. Thank you so much.
Good morning, Phil. Nice to see you. Okay, it's 10:02 in the morning. I'm Karen Reddick-Yurka. I'm chairing the Manzanita Planning Commission and will be presiding over this land use hearing today. This is the time and place set to continue the May 30th public hearing in the matter of the remand of a Land Use Board of Appeals decision to establish a hotel in the SRR zone. I'm going to call this hearing now open. The specific criteria for approval are summarized in the supplemental staff report dated June 9, 2023, and will be reviewed at this hearing. As reported by staff, the record was left open on May 30th for parties to present new evidence and argument to address the remand issue related to the Manzanita Zoning Ordinance 3.030 sub 4 sub A. That code section reads, standards. In the SRR zone, the following standards shall apply. Overall density for the SRR zone is 6.5 dwelling units per gross acre. Dwellings may be clustered on one portion of a site within the SRR zone and achieve a maximum density of 13 dwellings per acre, where at least 40% of the total lot or parcel area is reserved or dedicated as permanent space, as a public or private park area or golf course. The open space shall be so indicated on the plan and zoning map, and deed restrictions to that effect shall be filed with the city. All testimony and evidence must be directed toward this approval criteria or other criteria in the zoning ordinance that you believe may apply. Please note in their decision, the Planning Commission may reject comments or ordinance citations that do not directly apply to this section. Let's see, I'm going to go through the schedule again for today's hearing. We're going to begin with the city's attorney to summarize the issues that are remaining for determination. The applicant will have 15 minutes for their presentation, followed by 15 minutes for a presentation by Oregon Coast Alliance if they choose to do so, because they intervened on the city's behalf before LUBA and have been present in this hearing. The staff report will follow, and then commissioners will direct questions to those who testified. Those in favor of the proposal and finally those opposed to the proposal may speak for 3 minutes. Please limit your comments to the criteria and avoid repetition. If someone has already expressed the same thoughts, it is perfectly fine to state that you agree with the statements of a previous speaker. If you sent a written response to the proposal, please do not repeat your comments. They are part of the record, and then the applicant will be entitled to a rebuttal. After that, we'll close the public testimony portion of the hearing and generally limit the discussion to the commission. With the procedurals out of the way, I want to ask the audience first if there are any objections to the notice that was sent in this case. I hear no hands raised. Okay. Is there any objection to the jurisdiction of this body to hear and consider this case? Nope. Okay. Commissioner Collier has recused himself from the case. Are there any new declarations of conflict of interest, ex parte contact, or site visits by any member of the remaining members of this commission? I hear none. Were all of the comments received through 8 a.m. this morning posted to the city's website? I believe they were.
Yes, they were, Karen.
Thank you, Scott. And have all the commissioners received and read all of the evidence and testimony submitted to date? I have.
Yes.
Okay, great. Thank you. Does any member of the audience wish to challenge the right of any member of this commission to hear this matter by reason of actual or potential conflict of interest or bias?
And I have no hands raised.
Okay, thank you. We're ready to proceed with the hearing, and we'll begin with Suvani, if you would bring us up to date on where we are.
Thank you, Madam Chair. All right, so as you mentioned, we are back on a continued hearing on one remaining remand criteria. The remainder of the criteria the Planning Commission made preliminary findings about in the previous meeting based on the information submitted prior to the first remand hearing and the staff report therein. Those findings are detailed in the staff report and for this hearing. And for the people who participated in that, we don't need to go over that in great detail, but those are the findings, and the additional edits that the Planning Commission requested to the staff report can be found in the supplemental staff report, which was issued on June 9. So for today, the remaining issue relates to, as you pointed out, MZO section 3030 subsection 4 subsection A. And assuming that criterion applies, the applicant has agreed to comply with the density standard, and in doing so has testified that the open space will encompass 40% or more of the total lot or parcel area, and that it will include a private park, including a trail, and some portion of which will be open to the public. So the Planning Commission left the record open for a period of 7 days to allow the applicant and other parties to submit additional information and evidence demonstrating their position that at least 40% of the total lot or parcel area is reserved or dedicated as permanent open space as a public or private park area. And the parties have had an opportunity to do that during the open record period. After the open record period closed, the parties had an opportunity to submit not new evidence, but new argument in response to the evidence that was submitted during the open record period on this issue. And those comments are also included in the Planning Commission packet and available for review. There was one other item that the open record period was left open for, not for new evidence, but for any argument or responses to any testimony that any party may believe occurred during the deliberations portion of the Planning Commission meeting, and specifically relating to any clarification from Mr. Todd Mobley, who is the city's contracted traffic engineer. So to the extent that there were any arguments or responses to that, the public had an opportunity to submit those during the open record period for Planning Commission's consideration. So those are the only two issues that the record has remained open for. And then today will be the opportunity to present for applicant, the intervener, and the public to present information or argument, not new evidence, but argument relating to those issues to the Planning Commission.
Yeah, go ahead, Tom.
Ms. Miller, I have a question. You say there's only one issue relating to the density requirement, but we made no final determinations at the prior meeting, which this is a continuation of. So there was some discussion about the criteria for not overloading adjoining streets. And
Yes.
as far as I'm concerned, that has not been decided. And I'm hoping that we are going to have some discussion, at least among the commission, about that. In other words, that's not off the table in my view, and I hope I'm not mistaken about that.
No, you're correct that the items that you made preliminary findings about
Okay.
are not closed for discussion by the commission, but they're not available for new evidence or argument, except for as they relate to this issue. So, for instance, one of the issues that was available to submit new argument or testimony about during the open record period was how the proposed trail of the 40% open space may provide an alternative route for pedestrian or bicycle traffic.
Okay. Thank you.
And so the commission can certainly discuss those items that it made preliminary findings about, but the record is closed as to those issues.
Thank you.
Okay. Thank you. So we are at the point where the applicant has 15 minutes.
Good morning, commissioners. My name is David Peterson. I'm the attorney for the applicant. Thank you for giving us this additional opportunity. I would like to reserve 5 minutes of my time for rebuttal at the end. First issue I'd like to bring up is an objection to some of the testimony and evidence that's been submitted into the record. It was clear from this commission's order that June 6th was the deadline to provide additional testimony and evidence on the proposed open space dedication and as a private park, and 2, to respond to the Mobley testimony, Todd Mobley's testimony on May 30th. We submitted a letter by June 6th, and we spoke only on the first issue. We had no concerns with Mr. Mobley's testimony. So any evidence or testimony received after June 6th, the only way it would be admissible would be in reply to our letter of June 6th. And so there has been quite a bit of comment and testimony on other issues, most significantly vehicle traffic, and we would object to the inclusion of any of that evidence or testimony in the record. Turning to what I think is the primary topic of consideration here, it's the revised site plan that we submitted and its compliance with section 3.0304A of the Manzanita zoning ordinance. Once again, just for the record, I'll state our initial objection, which is that code provision does not apply because hotel rooms are not dwelling units. Nonetheless, the applicant is willing to make a dedication of open space as a private park that is generally consistent with that code provision as a way to facilitate approval of this project. There's 2 issues that have come up. One is how one calculates the 13 dwelling units per acre standard under that code provision. Some opponents of this project have said that, have testified that to back out the 40% dedication and then you multiply the remaining acreage by 13 to get your maximum density. We disagree with that interpretation. The code provision specifically talks about gross acres, not net acres. It says the density is calculated based on gross acres, so we believe our calculation is correct. is that after you back out the open space, you apply the 13 dwelling unit per acre standard to the overall acreage of the site, which in this case would result in a density far in excess of the number of hotel rooms. If the commission is inclined to apply the contrary definition, we are certainly willing to work with the city to possibly modify our unit count. Before doing that, we would probably we definitely revise our site plan to reduce the open space area further. Currently, we're offering to dedicate about 44.5% of the site to open space. We would reduce that down to exactly 40% so as to maximize our remaining density. So we're willing to talk about that if that's an issue that comes up later, but for purposes of preserving our record and possible appeal, we take the position that gross acres is the proper measurement. The commission also asked us to testify about what is a park, and we provided argument in our letter to that effect. Open space, undisturbed open space, or minimally disturbed open space can certainly qualify as a park. It is a park in many places throughout the state. Somebody at the last hearing, I believe it was one of the commissioners, pointed out that most Oregon state parks consist almost entirely of undisturbed open space. I would cite the example of Forest Park in Portland, I believe the largest urban park in the United States, which is almost entirely undisturbed open space with trails through it for biking and walking. So the open space that we're offering to dedicate with minimal improvements would similarly qualify as a private park. I would also just like to highlight one of the issues that came up in the last hearing, which was the question of violations of rules and enforcement on the park. Nothing about this project would prevent this, would either exclude the property from enforcement of city rules and ordinances generally, or prevent the enforcement of those rules. The city, I'm sure, has plenty of ordinances and code provisions about public misconduct, noise, public disturbances, curfews, perhaps, use of open space late into the evening. And there's nothing about this proposal that would prevent the enforcement of that. And certainly the applicant is willing to work with the city on enforcement so that it's not always, dumped on the police, for example. It's, they're certainly going to be vigilant about preserving the appealability of their project, and they're not going to be letting parties run wild in their open space, for example. So I think concerns in that direction are a bit misplaced. Once again, the city has general enforcement of livability standards throughout the city on private property, and nothing about this project would be any different. But that's all I have, unless, I don't. I'd like to also turn it over to Brent Aaron to talk about the trail issue.
That's a picture.
I don't know, we lost our video somehow.
Oh, it's there. There we go. Okay, thanks. For the record, Brent Aaron, traffic engineer with McKenzie. I prepared the traffic analysis. I wanted to speak real quick on the Greenlight Engineering comments, their letter of June 13th, I believe it was. The pathway, and then the frontage improvements on Classic, that issue. The pathway has been proposed as a way to address the pedestrians that would be walking along Classic in lieu of any frontage improvements. There are a lot of comments about the specifics of the design of the pathway through the site and the grades and so forth. What's shown on the site plan is a concept showing that it can fit and that the applicant's willing to include that pathway with an easement for public use as a pedestrian pathway. Actual design and figuring out the grades, et cetera, will be done at a later time. Certainly you can apply a condition that would require the pathway. But again, we don't believe bicycles would need to use that pathway. There are some grade issues, and given the low volume and the low speeds generally on Classic Street, it's appropriate for bicycles to share the road, and they'll probably be inclined to choose that over the pathway anyway. I would also note that if you were to widen Classic per the standard, as some have argued, that would actually tend to increase the speeds along the roadway. people tend to drive a little bit faster when the road is wider. So we think that the pathway is an appropriate solution to address some of those concerns. Yeah.
And then just one last thing from a technology perspective, I have our site plan available to share my screen. So at any point, if you want me to do that during your deliberations, I'd be happy to do that. So Elizabeth, any questions, the applicant will rest.
Okay.
Well, I have questions, but should I hold those until we hear from?
Yeah, let's see if Mr. Malone or someone else from Orca would like to speak for a few minutes. Not sure they're here.
Karen, I don't see any hands or, for somebody indicating they want to speak.
Okay.
And I actually don't believe I see Sean in here.
Okay. Well, we do have his letter. Let me see. Dated June 6th in our materials. Then if from here, if you don't mind holding the questions until the staff does its review. Yeah, your question might be answered, but if not, then we'll move on to questions next after staff report. If you're ready, Layla.
I am. And I'm just going to keep my remarks limited to the item at hand. The staff report that was put forward June 9th included some of the corrections that both the applicant and the Planning Commission requested. With respect to this one item, we just wanted to indicate that with respect to requirement MZO 3.0304A, the open space shall be so indicated on the plan and zoning map, and deed restrictions to that effect shall be filed with the city. Staff finds that plan refers to the proposed use as a planned development. So for context, please see MZO 3.0304C, requiring that proposals in the SRR zone be assessed under the planned development procedures. If approved by the Planning Commission, staff will initiate the zoning map amendment to indicate the designated open space. So at this point, it's really in the hands of the Planning Commission with respect to the evidence that has been submitted since the last hearing and until June 7th. And again, at the May 30th hearing, the Planning Commission, because the applicant had agreed to meet the density standard, the Planning Commission can determine whether this requirement is met or can be met with a condition of approval without making an interpretation as to whether some or all of the hotel units or dwelling units, or whether the density standard in MZO 3.0304A applies. Requested additional information from the applicant at the hearing about the design and characteristics of the proposed dedicated open space to determine whether the proposed use could meet the density standard requirement that at least 40% of the total lot or parcel area is reserved or dedicated as permanent open space. So I leave this in your capable hands and happy to answer any questions that you may have.
Sorry, I was muted. Let us open it up for questions from the commission to the applicant or staff. Yeah, go ahead, Tom.
I have a question for Mr. Peterson. We've been talking about the density requirement in section 3.030, subsection 4. And I know that you think it's not applicable, but reviewing the zoning code, it appears there's another density requirement. If you look at section 4.136, dealing with planned unit developments, which this is an application for, paragraph 2B under that section says the developer may aggregate the dwellings in this zone in cluster or multiple dwelling structures so long as it does not exceed the density limits of the comprehensive plan. for people who are following along, this is page 76 of the zoning code. To be.
Yes.
Okay, so it references the density limits of the comprehensive plan. If you turn to the comprehensive plan, when it talks about special residential recreation area, an SR/R zone, which this is, it says overall residential density shall not exceed 6.5 dwelling units per acre. If there's no exception to that, as there is in the zoning code provision, 3.0304 has the 6.5 requirement, and then it has this exception for clustering. The comprehensive plan doesn't have that exception. It's a universal 6.5 dwellings per acre requirement. And 2B of section 4.136 says, at least for planned unit developments, you have to comply with that standard. So I guess I'm wondering, is the 13 dwelling units exception even available?
So I have a number of responses to your question. First of all, it's our position that this is not a planned unit development. This is a permitted use, outright permitted use in the SRR zone that merely applies the procedures for approving a planned development. That does not make it a planned development. I've made that point previously. Number two, the comprehensive plan also may not be applied directly to this application. That was part of the Lugar ruling. As a limited land use decision, the commission is limited to applying its zoning code and the zoning code provisions that were in effect at the time the application was deemed complete. So a direct reference to the comprehensive plan is also not permissible here. Thirdly, I would say that your code provision 3.0304A is in fact the code provision that implements that language of the comprehensive plan that you stated. If the code provision impermissibly allows greater density than the comprehensive plan, which I'm not going to concede because I don't have your comprehensive plan, fully at hand. But even if it does, that's a problem for the city that should be corrected in a subsequent legislative proceeding and not one for the applicant, who's entitled to proceed under the zoning code provisions applicable to his application. So I guess that's a long way of saying I think your question is moot.
Well, let me follow up if I may, because I have your application and it says application for planned unit development, and it goes on to describe how you're going to comply with section 4.136, which includes 4.136(2)B. So by your own application, you have submitted to that rule.
Yes, and we went through a process with the city whereby the city found compliance with all applicable criteria except a few, which were then made the subject of this remand. So to reopen a criteria that, even if applicable, has already been decided and not appealed is not appropriate for this proceeding.
But it's all the same issue, what the density requirement is. We've been talking about that all along, and certainly on remand.
I would respectfully disagree.
Okay.
If the county commission, if the city council felt that we didn't meet that provision, then it should have said so in its order, and nobody appealed it.
Let me ask you about the Luba opinion. I thought that my understanding is that in accordance with law, you can't rely on comprehensive plan provisions unless they're included in the zoning code. But isn't this a pretty clear reference in the zoning code to the density requirement of the comprehensive plan?
No, I don't believe it is. You can't just generally incorporate the entire comprehensive plan. You have to incorporate it specifically. But again, at risk of sounding argumentative, you're taking this proceeding past the scope of the proceedings. You're asking me about issues that have already been resolved.
Was 4.136 to be discussed at any point before today?
I believe so. We'd have to go back and look at the staff reports from 2022. But I'm fairly certain that it was discussed in those staff reports. If I remember correctly, I believe the staff supported the application in part because it did cluster the units on a smaller portion of the site and reserve the remainder of the site as undeveloped open space.
Well, clustering is a good idea for communities that want to leave open space, but the point is, do you still have to comply with the density requirements? Okay,
Density requirements of what? Of the comprehensive plan?
The comprehensive plan as specifically incorporated into the zoning code at 4.1362B.
Well, I think the answer to that is no.
Okay, thank you.
I'd also direct your attention to the Classic Street Cottages development, which used the 13 dwelling units per acre standard in their approval. So the idea that 13 dwelling units per acre can be applied to a planned unit development already exists in the city.
Yes, but did this issue come up in that application? Do you know?
No, I don't know.
Okay, thank you. I now have a question for staff. Turning to 3.030.4, the zoning code density provision. Several people that have commented on this application have construed the 13-acre, I'll call it the clustering exception, to apply to the reserved portion of the application. In other words, if you set aside 40% as open space for a park and leave 60% back to be developed, that the 13 dwellings per acre applies to the 60%, not to the whole 100% of the overall development. So, at least to illustrate this to my way of thinking, if you had a 10-acre development and you reserve 40% for a park and you have 60% remaining, then you get dwellings on just the 13 dwellings on the 60%. So you'd get 72 dwellings on that 100 acres. You wouldn't get 130. The full 10 acres times 13. So what I'm wondering is, has the city in the past interpreted this provision one way or the other?
And Thomas, Layla got kicked out of the meeting, so I'll answer that question. It's based on gross acreage, and you set aside 40% of that. The calculation for the dwelling units is based on the gross acreage, not the net acreage after removing 40%. That's how it was done up in the Classic Street Cottages, and that's how it's been done in the past.
Well, I'm curious because the first sentence says gross acre, but then the exception just says acreage, not gross acre. I guess what I'm wondering specifically, was this just nobody noticed it in the Classic Cottages development? Or was it actually argued and a decision was made, this is how we're going to interpret it?
That's a good question. I don't have the exact answer for that. Karen maybe can weigh in on this one.
I can. In the past, we have interpreted that to mean that the density is based on the gross acreage. So if you have, I don't know, what do we have here? 3.1 acres. That's the total that you divide to get the number of dwellings that are allowed, not before you reserve. 40%.
Okay. And so that was actually decided in the classic cottages thing. So it sets a precedent for the present application, not
yeah,
just
it's
nobody noticed.
More than just the classic street.
Okay.
It's since I've been on the commission, that's been the interpretation.
Okay.
This, I don't think we've ever had an exception to that. I have to go back and look, but I believe that's the way we've interpreted it.
Yeah, I'm done. Thanks.
Karen, you're muted.
Thank you. Yes. Frank, would you like to go ahead? I see you have your hand raised.
Yes. Question for the city. Are we at our short-term rental capacity in the city of Manzanita?
Frank, are you talking about our maximum cap right now?
Yes.
Yes, we are.
Okay. The next question is that in this SRR area, if a property owner had a house there and decided they wanted to do short-term rentals, they would not be permitted, right? Because we're at our cap.
The only way they would be permitted is if a license gets turned in,
Right.
then we would be able to issue them a license.
Or if they declared that their property is now a hotel, would that change things?
Hotels are managed differently than the short-term rentals.
Okay.
As far as that goes.
But that person that owns that property could then declare that property a hotel, could they not?
If it meets the standard of a hotel through Tillamook County and the state.
Right. Which are the standards that we're talking about for these structures that are being proposed to be built that we're talking about today?
I believe so.
So anybody or some of the property in the Highlands or over by the recycle center, if I wanted to buy a big lot and put multiple dwellings on there, single family homes, but call them hotel rooms and met all the qualifications and standards, then I could do that as well. Is that what I'm hearing?
Possibly. I mean, they would have to go through the same procedure to be approved as a hotel.
Okay. So that seems to be part of my problem, is that what is a hotel room, or what is a hotel? Some of these buildings that are being proposed are 1,000 square feet, 2-bedroom, laundry room, multiple bathrooms, which to me, I don't know how that crams into a criteria of a hotel room. It just seems like they're all single family dwellings that are being called hotel rooms so that they can circumvent the short-term rental agreements.
I think I'm going to defer this one to the city attorney to answer that, because I believe this has been discussed in the past meetings as far as are they dwelling units or not. By city definition, you could say that, but by the application and the way the facility is being run, it's all on one property, then they are hotels.
Okay.
Similar to...
I wasn't here for all of the previous...
I realize that. So, it's similar to the, over on Lanita, what is that hotel complex called? They're individual units, similar concept.
Okay.
But they are run as a hotel. And what you're speaking of is these are all on one property as a hotel, whereas in order to be single family dwelling, they would have to be subdivided into individual lots.
But anybody with a single family home that wanted to circumvent the short-term rental agreement could then just apply to be a hotel.
Not necessarily. So you can only have, per 5,000 square foot lot, 2 dwelling units. So if you have a single family home, that question I can't answer. If they could be, I don't believe they could be individual homes considered hotels. You couldn't put a hotel in R2, R3. They're allowed in the commercial zones in SRR.
Got it. Now I have a question for Mr. Peterson, if I may.
Yes.
Okay. Going back to the private park project that you talked about and how that would be policed, it sounded to me that you were putting most of the onus on the city to make sure that the rules that may exist already are applied to that space. If it's a private park, I don't believe that the onus should be put on the city like that, as the way you spoke about it. If it's a private park, the property owner has the responsibility to make sure that things are going as they should be. If you have a hotel and you have a pool and 20 or 30 people showed up to have a pool party, management should be responsible for making sure that those people belong to the hotel. And if they refuse to leave, then the police may be called. It's the same thing if you have a private park and 25 people show up because they decided, hey, this is a great space, let's all get together here. And there's nobody, at the hotel that's taking care of business. You're saying that the onus belongs to the city to make sure that people are not lingering too late into the evening or doing whatever they're doing, being too loud. But also what happens when 20 people show up in vehicles to a private park that's not being policed by the property owners? Where do they park? All of these things are possible. It just sounded like you were putting the onus on the city.
Well, if that's the impression you got from my testimony, that's my failing, because that's not what I meant to say at all. It is certainly, in the case of any private property, not just this hotel, but any private property, it's initially the responsibility of the private property owner to make sure that the use of their property doesn't disturb their neighbors, complies with general standards of livability and city rules and ordinances and things like that. And in this particular case, the hotel owner certainly would take primary responsibility for enforcing good behavior on the park. That's not only common sense and good neighborly conduct, it's also good for business. But there was certainly an implication in the previous hearing that somehow the city's hands would be tied. And I wanted to make clear that that is not the case. Just like you have with STRs, your expectation is that the property owner is going to enforce your good neighborly standards. But if for some reason they don't, there is always the opportunity for the city to enforce its code. So it's not like your ability to enforce the code is lost. Certainly, I would not expect the city to have to do that. And in this particular case, speaking for my client certainly intends to make sure that his property is used reasonably.
Okay, thank you.
Mm-hmm.
Any other questions from the commission?
Yes, I have one for our legal counsel, if I may. Hi. The LUBA remanded this in part because they said that the city council had improperly relied on a provision of the comprehensive plan that had not been incorporated into the zoning code as required by ORS 197.1951. So I'm wondering, in your opinion, if you look at section 4.1362B, the one I referenced earlier, which says that the developer may aggregate the dwellings in this zone so long as it does not exceed the density limits of the comprehensive plan. Is that an acceptable incorporation of the comprehensive plan density requirement, in your opinion?
So before Luba's opinion, I may have said that that was a reasonable interpretation based on the context in the text. However, after Luba's opinion remanding this, I think that that incorporation is substantially the same as an incorporation that Luba found to be not appropriate. So the one that Luba was considering was in MZO 4.1363C2, which also says that resulting development will not be inconsistent with the comprehensive plan provisions or zoning objectives of the area. And even in that situation where the provisions in the code specifically reference the comprehensive plan provisions and appear to require compliance with them, because this is a limited land use decision and because the use is outright permitted in the underlying zone, essentially the comprehensive plan provision, you can't refer outside of this document, the code. So I think the question that you're asking is, does a similar reference to the comprehensive plan allow the city or allow the planning commission or require the planning commission to go and look at that code provision that it implements? And I think that based on the remand decision itself, the answer is no, because even though that's exactly what it says in the code, that type of reference is not what LUBA's looking for here. What LUBA's looking for here is that the specific provision in the comprehensive plan actually appear in the text of the code when you're assessing this type of an application. So if that density standard word for word appeared in the code, then it would be applicable. But in this situation, I think, there's also the issue of the world that we are in now, based on where this LUBA remand has landed the application back before the city. So the density standard that LUBA remanded and directed the city to consider is the one that is in MZO 3.030. So that's the question that's been presented back to the city. And just as the applicant and the intervener can't go into issues that are not on remand, the question before the city is really, can the applicant comply with that provision?
Thank you.
Are there questions from other commissioners? For either the applicant or for staff? So I guess I just have kind of a clarifying question.
I'm sorry.
Go ahead, Tom.
We have conflicting evidence about whether the open space in the now revised plan, the open space as park, adds up to 40% of the lot. The applicant says it does, but there's testimony from a Mr. Gumpenberger, I hope I'm not mispronouncing his name, where he says that you're not at 40%. And unlike the applicant, he shows his math, has a lot of numbers, looks at lot sizes. I have no idea who's right. How do we resolve that conflict? I guess I would ask Ms. Miller that.
Karen, can I weigh in on this?
Sure, anybody can.
Go ahead, Scott.
Because I did read the comments from Mr. Gumpenberger and did go in myself with my review software and calculated, and I came up within probably 800 square feet of what was calculated in the 44%. I think I was a little bit under that, but that could be placement of cursor and measurement points. So I used my software, and I'm not sure if the applicant has that on his computer to where he can actually highlight the green area and it automatically calculates with the current, new software and stuff that is out there today. So it's done by computer, not by hand.
So Scott, you think that it is met, notwithstanding Mr. Gumpenberger's calculations?
Correct. And if I remember correctly, the drawing he was using was the previous one that showed the green space along the golf course, the open space. I calculated mine based on the newest submittal for evidence.
Okay, thank you.
You're welcome.
Okay, anybody else want to weigh in on that? It seems to me that we have a choice to make on this issue, and that is, do we want to call these units dwelling units in order to have them meet the standard? And in that, so I guess that's the first question before us is, are these dwelling units? The applicant says they are not. They're a hotel. And I guess really this original site plan was, had information about what some of these rooms would look like and what some of the layout and the room configurations were. But I'm not sure that we're looking at that anymore because that was part of a design review that did not happen. It became a planned unit development review instead. So that's the first question is, are these dwelling units? And if so, do the 34 units meet the standard for 13 units per acre? That's the first question. The second question is, if these are not dwelling units, is this project allowable under our zoning code? And considering that we don't have a definition of a hotel and we don't have a definition of park or open space, how do we interpret our zoning ordinance to cover this kind of a site plan? So I guess that's the first question to me. And please let me know if I'm off track in any way in how we're looking at this. But before we do that, before we begin our own discussion, I want to make sure that we invite, I'm assuming that there are no more questions from the commissioners for the applicant or for staff before we move ahead. Okay, I want to invite any persons in the audience who wish to speak in favor of the proposed development to raise your hand.
Hey, Karen, I'm not seeing any hands up.
Okay. Are there comments from the public in opposition to the development? And I again would caution you to please not repeat anything that you've submitted in writing because we have read it. So this would be any additional comments or arguments.
And I have one hand raised. Ivana, go ahead and unmute yourself.
Yeah, hi. This is Ivana Ovino. I live up in the Classic Street. I'm a full-time person here. And I'm just so dismayed about this whole procedure that's happening right now. I don't even know if this is like legal. It just feels, first of all, I feel that you did not tell the citizens or Orca that we were allowed to have oral commentary. You said you could only provide written comments. And so no one was prepared and Orca is busy doing other stuff and the lawyer isn't available. And I just feel this is so unfair. And meanwhile, the applicant is allowed and his lawyer is allowed this constant rebuttal of everything that we find wrong or we have questions with. You're going back and forth with him. But the vast majority of Manzanita, guys, hello, everybody in Manzanita do not have such opposition about this project, and yet we're given no voice. I just don't understand how this is an okay thing. I just feel like you're kowtowing to the developer, and I'm sorry if that's how you may not feel like you are, but that's how it's coming across. And I just think Mr. Peterson, by saying that other projects were done incorrectly makes this one be allowed to be done incorrectly is such a bad argument, in my opinion. I mean, you're pointing to this and that, and they didn't do their percentages correctly, so that allows me to play games with my numbers too. it's so unfair. And also the definitions. Like, you want to play with some definitions, but some definitions you don't want to play with. And it specifically says park. It doesn't say open space. It says park, private or public, or golf course. That's what it says. And if you look up the definition of a park, it's not a trail. It's not bits and pieces. And you're still doing that. And I just feel like you're just getting around all the meanings, all the ordinances, and you just want to push this through, even though no one in this community wants it. You're not from this community. Your developer isn't from this community. He may have grown up in Arch Cape, but he lives in Portland. We can all Google things. Hello. So I'm just so disappointed in this whole meeting. Thank you.
Okay, Karen, we have another hand up. Sandy Wood, go ahead and unmute yourself, Sandy.
Okay, I just wanted to agree with everything that Ivana said. She said it very eloquently, and I just appreciate her comments and hope you will listen to us. Thank you.
Okay. Anybody else?
I have a couple more hands up so far. Bill Gumpenberger, go ahead and unmute yourself.
I've got a couple of things I want to say. First off, Karen, you brought up, you read off MZO 3-034A, and you read what it actually said. But the paragraph above that in the staff report of June 9th was the applicant's response. And the applicant stated in that he is willing to reserve or dedicate 40% of the site for open space or public or private park area or a golf course. The zone actually says 40% of the total lot or parcel area is reserved or dedicated as permanent open space as a public or private park or area or golf course. It's not or public or private park, it's as a public park. When you look at what the applicant has submitted, he references in the legend on the maps, both of the May 30th and again on the June 6th, dedicated permanent outdoor space, open guest park space, or public walking path. He's referring constantly to open outdoor space. He also comes up with a square footage of his outdoor space of 73,000 square feet. Well, let me back up. In the first one, he comes up with 79,000 square feet. In the second map that he proposed on June 6th, he comes up with 73,862. How does he come up with those numbers? Because he shows no math for that. My belief is that he takes the other square footage that he shows and backs it away from the 166,000 total square footage. I've detailed this in my letter of June 3rd and my letter of June 8th. You can look at the June 8th letter, and you've got it in your possession. Try to do the math and come up with 73,000 square feet. Now, Scott just a minute ago said that he thought maybe what I did in my calculation, I used the open space next to the golf course. No, sir, I did not. I used the 10-foot, in my June 3rd letter, I used the 10-foot by 635 foot of a setback. It's only 10 foot wide. If you look at, so I believe in my calculation, as of the June 30, of my June 3rd letter, I come up with 62,530 square feet as what he's got as a park. Whereas in June 6th, he's got 59,716. In both cases, he's short. Now, I don't have application of the software that Scott was talking about. However, it doesn't take a genius to look at that map. And by the way, that lot, the whole thing, when I look at it, is somewhere close to 1,850 feet, lineal feet long. And that's what the length of that trail is. I would like somebody to show me how he comes up with 73,000 square feet of open space is going to be a park. It just doesn't calculate, folks. I just don't see it. And if someone can show that to me, but I don't see how you can approve this based on those kinds of numbers when they don't add up to anything. It's just pie in the sky. I feel like the applicant is playing loose with the zoning laws and the language within that, using the word or instead of the word as. It's clear as daylight. It's in the staff report. Looking at my notes. I've got one other question I find kind of interesting. I've built 6 residential units in this city over the last 20 years. The only way I ever got an address for that was when I paid my permit fee. How do we have an address of 698 Dorcas without paying a fee? Secondly, whenever I got an address, it was wherever my front door faced. There's no front door facing Dorcas on this property. It's all facing Classic or the golf course. It's kind of a moot point, but it kind of bothers me, just the overall aspect of it. And I agree with Tom. This thing was a planned unit development, and that's what's on the notice of a hearing on every case. This project shouldn't go through. I'm going to have, where I live, I'm going to have to look at all the party goers in that great little open space over there that he's got. And it just doesn't make sense. I rest my case.
Okay, thank you.
Okay, Karen, I have one more hand up. It's Micah Russo.
Hi, I'm Mika. I spoke at the last meeting as well, and I just want to, as a citizen of Manzanita and a full-time resident here as well, I just want to agree with what has been said before, what Ivana said about the public not being prepared or aware that this was a meeting that would accept public commentary. I think we all left the meeting understanding last session that written comment was the only ability for us to have our voices heard, which is how we all prepared for this meeting today. So I am on multiple text threads with people in the community right now, and I think everyone's really flustered and surprised and scrambling to try to respond and be able to represent our best ideas off the cuff, and that doesn't seem very fair. So I agree with Ivana, agree with Sandy, and agree with Bill's calculations and questions to what the applicant has not presented on his drawings. I've already covered that in my letter from the previous week, specifically speaking about the logistics of a walking path, and tried to share photos to show all the infrastructure needed to create that 40% of open public or private park space, and what it would entail to make a grade that was walkable, how that would be able to swish between the road and the hillside. So I'm not going to get into all of that. I think it's just really worth considering. I asked the Planning Commission to consider that because his drawings do not have that information. They don't have any scale of elevation, anything indicating what the actual reality of walking that path or what that 40% would entail, as Bill spoke to. And then the last thing I wanted to mention, I don't fully understand the remand and the LUBA, the legal speak that the team has gone through. I trust the attorney and everything that's been said, but I did want to reiterate Tom's point and question, and I think also Frank's point related to the dwelling unit question and the kind of B or C ordinance, because my understanding of LUBA was presenting it back to the Planning Commission and asking, when we look at the density standard, it's asking for more information of what does the city think. Do these hotels apply as dwelling units as defined? We need to have more of a clear stance on that because there's not one originally. That was my interpretation. So I think that those questions are totally fair. And I think that the excuse that, we've talked about that in past sessions does not answer the question. It does not give Frank or Tom or the commission or us as public citizens an answer. It's really just leaning on a vague response that doesn't exist. if they can answer it today, if they answered it last year, they can answer it today. And the fact that they didn't tells me a great deal. So I urge the Planning Commission to deny this and to trust the questions and commentary that they have related to this. So that's all I'll say. Thanks.
Okay, Karen, I have another hand up. Sean, go ahead and unmute yourself.
Hi there, my name is Sean Danaher. I'm Mika Russo's partner. I echo what other members of the Manzanita community have shared this afternoon or this morning. It was very clear that there was not a public commentary session. In the last session, it was clear that we were not going to have public commentary outside of written responses. So I think
I'm going to interrupt you here. That argument has already been made. So if you agree with it, please say so and move on to something different, if you don't mind.
Fair enough. I'm happy to. I just want to direct, I guess I just want to sit back really quick and go, what has changed since the last meeting to now? I'm looking at the Manzanita Loft site plan that was submitted by the applicant on June 5th. The only thing that I see that's changed is a line that now goes, instead of to a parking lot, which was not appropriate, is now drawn around the north side of the residence. And that line, that trail, goes through parking spaces. It goes through parking spaces, and then it continues on, and it goes through more parking spaces until it exits the intersection at Classic Street and Dorcas.
I said in my letter.
I just want to step back and say, this would not pass a 100 level architecture class. Okay, this is so unprofessional. This is so embarrassing that you have adults saying, oh, this is a concept. Oh, this is a concept. Oh, believe us, this is a concept. We're going to get to this. Trust us. We're a year into this process. There's no description of grade. There's no descriptions of how this trail would actually look. Has anyone even gone to the site as members of the Planning Commission and looked at what this proposed public walking path would even look like? There's no room where these bench alcoves are proposed to be located. There's an incredibly steep grade there with blackberry bushes everywhere. This defies logic. And I just still cannot believe that we're okay with somebody drawing a two-dimensional line on a piece of, on a PDF with no letterhead. I might remind you, the letterhead's gone now on these PDFs. Before, there was actually a description of who's doing these designs. Now there's none. There's none. Where's the letterhead? I don't see it. So it's amazing that a 100 level architecture student or landscape architecture student would have to prove his or her case to pass a class, yet we're okay with adults drawing lines through parking spaces and saying, yep, that's a trail. Yep, and that now gets lumped into the open space. It's remarkable. And I would also just share that on the City of Manzanita's homepage, there's an entire transportation plan draft that specifically speaks to this section of Classic Street. And I have a hard time understanding how this proposed trail is in harmony with the transportation plan that the City of Manzanita is proposing to spend well over $1 million towards constructing better transportation, better ability for people to walk alongside Classic Street. But hey, they drew a line along the side of the road. That means it's a trail. That means it's okay. And this wouldn't, again, pass a 100 level architecture class. This is embarrassing. I rest my case.
Thank you.
Okay, Karen, that's the last hand I have from the public. Frank does, oh, Bill Gumpenberger just raised his hand again. Did he still have some time left, Karen?
If there's a new argument to be made on the specific issue that we're talking about,
The argument I want to make is that I think the applicant needs to prove his 73,000 square feet of open space as a park. Not the city to prove it for him. I want the applicant to prove it. Thank you.
okay, thank you.
Okay. Okay. Now the only other hand I have is Frank. I'm not sure if he can speak during the public comment period or if you had a specific question for one of the comments. But go ahead, Frank.
Oh, okay. I just wanted to thank everybody for taking time to comment. Yvonne is particularly made a observation that Orca was not informed. Karen, I just wanted to see if we could, as a body, address the concerns of a number of the people that just spoke about whether or not people were informed that they would be able to speak today.
I might ask Suvani to jump in if Karen, you want me to answer this
that's
question.
what I was going to suggest. Thank you.
Okay. Maybe Suvani, do you want to take this or do you want?
Certainly. Well, I think you also have some information about the kinds of questions that staff were receiving and answers that they were providing during this process. But the notice itself says that the June 16th continuation of the remand hearing will be limited to argument relating to the evidence and arguments submitted during the open record period. So the open record period would be limited to those written submissions. And then, of course, anything that's submitted in writing doesn't need to be restated orally. But I think the expectation was that this hearing would be a continuation of the previous hearing and would proceed in a similar fashion, just with these limited issues, and that's what's reflected in the notice.
But there was no indication that people would not be allowed to speak.
No. A continued hearing implies, and I think, correct me if I'm wrong, Suvani, that there will be additional testimony allowed at the hearing related to the specific issues that were left open. I also want to note I received at least a dozen emails from folks asking me to keep the record open, which is not within my authority, but I did have a standard response to all of those emails. And what I said in those emails were parties can submit argument but no new evidence up to at the hearing in response to any evidence, et cetera, et cetera. So I think that I can appreciate folks maybe not being as familiar with the process, but a continued hearing does imply additional testimony. And if I indicated in these emails to folks that you could provide additional argument but no new evidence at the hearing.
And I just want to state for the record that we received all of the comments and read them and take them to heart where we can.
And I do want to also add that staff did take the extra step to email Orca all of the additional evidence and comments as they came in. So as we shared them with Planning Commission and with the applicant, we also did share that information with Orca.
Okay. So at this point, then I will close the public testimony portion of this discussion and will invite discussion.
Is it? I have
wait.
my hand raised. Is that? Can I speak?
Who has a hand raised?
Mika.
Do you have
a new comment? It's a new comment. It's related to the open period and speaking for the public. I just wanted to, maybe it's just me, but I remember very, very distinctly at the end of public commentary and the discussion from the last meeting, I remember the Planning Commission member, Tom, saying very distinctly, we can't have more discussion. I've read so many hundreds of pages, I'll read more pages, but because we spoke for like 3 hours. So I remember from that conversation, and I think everybody on the call remembers, that the takeaway was written commentary. We as a planning commission are happy to read more, but we can't have any more public dialogue. And perhaps more information was changed in the summary afterwards and posted to the website. Not all community members are checking the website every day or have access to it. So everyone's tuning in to listen to these meetings and taking the planning commission seriously. So maybe that's where the confusion came from. I remember that very, very clearly. Sean is letting me know that that was said at the 3 hour and 56 minute mark of the hearing last time. So just to be really clear, that's what we all remember, was that written commentary was the way to provide testimony and respond to the applicant's new evidence.
Okay, thank you. At this point, then, I'm going to turn it back over to the applicant to respond to any points raised so far.
Thank you very much. I would just like to point out that for every person who's at this hearing, the fact that the notice may have confused them is irrelevant because they've actually had their opportunity to participate. So I can't see where the prejudice would lie against people who actually showed up and were able to testify, or at least had the opportunity to. To respond to a point made by Mr. Squillo, one can't just declare a short-term rental to be a hotel room. Being in the hotel business has a number of governmental requirements that would apply. You have to get a state license. You're going to have to get a business license. You're going to have to go through this process, the same one that we're going through, assuming your property is in the SRR zone. In order to get your hotel approved, you can't just raise your hand and say, now I'm a hotel. So it's a little bit more complicated than that. Mr. Gumpenberger's comments about the precise accuracy of the site plan. Obviously, showing a site plan that is pretty close to accurate is important so that you can get an understanding of conceptually how it's going to look. But the precise square footage is actually not crucial to your decision here, because what you're going to do, assuming you go in the direction that I think you're going to go, is you're going to impose a condition of approval that requires the applicant to dedicate 40% of the site as open space for a public-private park. And then staff is going to confirm in the site development process that in fact 40% of the site is being dedicated. So with the condition of approval will solve the problem that's being raised, assuming there even is a problem, that there's some inaccuracy in the site plan. And then lastly, there have been a number of comments that are seeking rather granular levels of design review of this project. But as Ms. Heyman pointed out, there is no design review for this project, right? This is an outright permitted use in the zone. I keep coming back to that. And as long as the criteria are met, the design principles, to the extent the city has regulatory authority over those, are going to be resolved during the building permit process. You can't shoehorn a design review procedure into one where one does not apply to your code. That's all I have. Thank you.
I just want to.
Oh, I'm sorry, Mr. Sorelli wishes to speak.
I just wanted to add a couple of things, and similar to what the city staff said, that yes, the open spaces, as David mentioned, would be a condition that would need to be met. But I can guarantee that with the program I use, that the square footage is the 73,000 plus. So I just wanted to note that and can easily illustrate that. And then wanted to just touch again with what was brought up with Frank. And I think Lee at a previous meeting had the same questions. They will be managed. We will take full responsibility of monitoring the land and making sure that everything is good for the property, good for the surrounding neighborhood, and well managed, and no police force or anything would need to be called in unless it was previously taken care of on site. So just want to point that out.
Okay, thank you. I'm now closing the public comment portion of this discussion and will invite discussion by the commission. Commission members may ask clarifying questions of the applicant, audience members, or staff, but we are at the point where discussion will be limited to commission members and no new evidence will be taken at this time. So we're at a point where we can have a conversation among ourselves if we like, or if there are additional clarifying questions to be asked, let's get those out of the way first. Go ahead, Frank. Would you unmute yourself?
Thank you. Just to point to what Mr. Peterson said, I had no doubt that there's the inability of anybody to just magically declare that their property is a hotel any more than because a house has a kitchen that they could declare themselves a restaurant. I was just making the point that they could go through the process if they own a property to circumvent the short-term rental agreement by making their property a hotel and doing all the due process. So that was my point. Thank you.
Aaron?
Yeah, go ahead.
I'd like to just begin the discussion by thanking everybody who's participated in this process. The applicant, of course, but also all of the members of the community that have submitted comments in writing or testified. This is obviously a very important issue for the town, and I want to assure everybody that at least I have read everything that has been submitted, read it several times over, studied it, studied the zoning code, everything else. And someone asked, have we gone there and looked at it? Well, I've been past there many times prior to joining this commission. But indeed, just this morning, I went out there and walked Classic Street and looked the site over. So it was fresh in my mind in preparation for today's decision. So to the extent humanly possible, I've done everything I can to listen to everybody and try and understand your points. And I assume that all the other commissioners have done the same.
Yeah, go ahead, Lee.
First off, thank you, Tom. You've been very, very helpful and supportive today of considerations. I also want to echo Tom in his address to the community. We know this is a very sensitive project. We do understand and probably have some similar feelings to a lot of you. You're not alone out there, but we're faced as a planning commission with a really monumental task to determine whether or not this project meets muster. Several of you raised some great points, both in writing and orally, and we consider all that. We have to take that into account before rendering a decision. A couple of things that I wanted to share. We're kind of stuck with not having definitions of parks, definitions of hotels.
Lee, it looks like you muted yourself. Lee, we can't hear you.
You're muted. There you go.
Okay, can you hear me now?
Yeah, we can hear you now. Could you repeat that, please?
I really apologize. Technology gets in the way sometimes. So we have no definition of a park. We have no definition of a hotel in the ordinance. I can honestly say from reviewing planning and zoning ordinances from other communities that we're not alone. It's not uncommon to have omitted those types of informational pieces that would be helpful when we try and make decisions. But in lieu of anything else, I'm just going to read a brief statement out of Wikipedia about a park. A park is an area of natural, semi-natural, or planted spaces set aside for human enjoyment and recreation. It doesn't state what it has to look like. It doesn't state what it has to feel like. Obviously, English gardens are a lot different than, I think somebody earlier today brought up Forest Park in Portland. Extremely rugged, very, very rural in its feel, but it's still a park. Regarding regarding hotels. A hotel in Wikipedia is a commercial establishment offering lodging to travelers and sometimes to permanent residents. So again, it's pretty subjective in its use. There isn't anything in any definition that requires a front desk. There isn't anything that requires continued on-site service by the establishment. And I want to point out that Mr. Sorelli at the last meeting went on record to say that he was supportive of having on-site management for a fair part of the time, and the rest of the time that there would be someone in the community, not in Cannon Beach or Arch Cape, but someone in the community who would be able to respond to concerns within a 20-minute time frame, similar to the short-term rentals. So if I haven't been clear, we have a lot of impediments that force us to make decisions based on subjective information. And I really do respect all of your comments today. And I thank you for being involved. The only way that things can change is through your involvement. You brought up some good points, some things that we need to reconsider heavily when we rewrite the comp plan and are involved in zoning ordinance changes. So with that, thank you.
Okay, I'd like to give Mr. Sorelli an opportunity to make sure that what you stated as his comments are accurate.
Yeah, I completely agree with what was stated about on-site management and keeping close review of the grounds and ensuring that it's run properly as the business, as the hotel itself, as well as run well for the community. So I agree with everything that was stated.
Okay, I hate to quote somebody and not have the opportunity to make sure that the quote was accurate. So, Frank, did you have something else?
Yeah, in all due respect to Lee's Wikipedia definition of a hotel, I would rather use the state of Oregon's interpretation or specificity of what they call a hotel or inn. And this is in the Oregon Legislature, Chapter 699, the innkeepers and hotel keepers portion of the legislation that says it's a property, however owned and including a condominium under ORS Chapter 100, in which rooms or suites of rooms are generally rented as transient lodgings and not as principal residences. So that gets us a little closer to what the state defines as a hotel, as opposed to Wikipedia.
Okay. Great. Phil, did you want to unmute yourself and add anything or subtract anything from the discussion? You got nothing to say, or you can't get yourself unmuted? Okay, I just want to make sure that you've had an opportunity to add to the discussion, Phil. Oh, there you go.
I'm sorry, Karen. No comment.
Okay, great. Thank you. All right, so how do we proceed from here?
Well, I'll start it off. We discussed last time that I thought we came to the conclusion that we didn't need to decide whether these were dwellings because the applicant had agreed to apply with the density standard in the zoning code. I'm I don't know why we should revisit that. In any event, if we need to reach that issue, I'm persuaded that these are dwellings as used in the code. The applicant keeps saying a hotel isn't a dwelling unit. That's irrelevant. Whether it's a hotel or not is meaningless. It's a dwelling unit if it meets the definition in our code, which is a place that people occupy that has certain other characteristics. And it seems to me from the materials submitted that most of the units in this application would qualify as dwelling units, if not all of them. It's hard to tell with some of them, if only because the applicant hasn't provided sufficient information, but that burden seems to be on them. So I have no problem concluding that these are dwelling units and that the density requirement in 3.030 4A applies to this application, and that we have to figure out whether this application satisfies it.
And do you have a thought about whether the application satisfies?
Yeah, I do. In my opinion, it does not satisfy that criteria.
And what are you basing that on?
For the following reasons. As we explained last time, to reach the 13 dwellings per acre exception, the application has to dedicate 40% of the lot as open space as a park or golf course. It's not just simply open space. Well, since our last meeting, the application has changed the site plan to turn a lot of what was previously indicated as open space into what they're now describing as a park. Mostly what they've done is just extended a lengthy, narrow strip of land between Dorcas beneath Classic Road, basically the shoulder of Classic Road, and called that now part of their park. Park isn't defined in the code, so it should be given its plain or ordinary meaning. It should be given the meaning that people commonly understand when they think of a park. There's no way that that space I've just described is a park. The way it's configured, the way it's located, it is basically the shoulder of Classic Street. It's sloping. It's narrow. It's so narrow that on this site map, at some places, it is no wider than the pedestrian pathway that they propose running through it. It's a space between the pavement of Classic Street and the pavement of a parking lot. Now, Mr. Peterson says that a park does not have to be improved. That's right. You can have places that are undisturbed in a natural area, and they can be parks, Yellowstone, Glacier, Forest Park. He says undisturbed places can be a park. Sure. This is not undisturbed. It's graded. The trees have all been removed. There's gravel over parts of it. It's covered with blackberries and other invasive species. There's no way that strip of land is a park. And if you remove it, then you haven't dedicated 40% of the lot to open space as a park. There is no way that anyone in this community would look at that side of the road left in that condition and consider that to be part of a park. Other places, other parts of the open space below what they call the cabin cottages are park-like, but certainly that part isn't. And I question whether the rest of it that extends all the way past the Highlands Drive down along the other shoulder of Classic Street down to Ridge can fairly be considered a park either. It's not a park. It might be open space, but that's not sufficient. So I don't think that this application meets that criteria, and I would so find.
Okay, anyone else want to piggyback onto that?
Can't hear you, Lee.
Yeah, here we go. Respectfully, I have to disagree with you based on the opportunities that we have within the ordinance to apply what space is a park and what isn't. A park is an open area, open to the sky, that provides opportunity for recreation for individuals. I don't understand your reasoning for the area south of the proposed development or the proposed cabins. Maybe you've got an argument for the hillside, the slope, i.e. down below Classic. I don't think we can go there. I guess that's what I'm saying. With the slope, perhaps, but not with the area south of the development.
I agree with that, Lee. Just to follow up, I thought I did say the place south of the smaller cabins, but the thing is, if you just confine the open space as park to that area south of the cabin and do not include the shoulder of Classic along that whole length there, you do not get to the 40% as park requirement. And it can't simply, in my view, it doesn't say just open space as park or golf course. So park or golf course has to be something different than just open space generally, as we discussed last time. You can't just call the front yard park. It has to be park-like. And I would defy anybody to walk along Classic Ridge now and look down to 10 or 15 feet below the road there and imagine that 10 or 15 feet of blackberry bushes with a parking lot below it and say, this is the park. I can't imagine anybody here would like that park named after them. It's not a park, in my view. Doesn't meet the criteria.
Okay, I'm not going to pick on you specifically, Frank, but how do you feel about this discussion at this point? Can you unmute yourself?
Sorry, get used to that. I think what Tom is saying is pretty much on point. Particularly the part where he's saying where the blackberry bushes are and on the edge there, how that gets incorporated, I don't know. And I know there's been references as to the cottages across the street where they chopped up whatever that area was and used it in sections and then collectively called it open space. But that doesn't seem like that was appropriate in that instance, nor is it appropriate to be able to do that here, based on the definitions that we're hearing and reading.
Okay, Phil, you want to weigh in?
I agree with Tom's presentation. I don't see how you could, to me, park means that you can actually interact with the space. And I don't see how you can interact with the space that is of that terrain that exists on that site. Specifically, the area along Classic.
Okay. I'm really struggling with this. On the one hand, I agree with you, Tom, that part is, that part of, just above the parking lot isn't park-like because it's covered with blackberry bushes, but I don't think that we can look at the vegetation as it is now and assume that that is permanent. However, that, those blackberry bushes do give cover to wildlife, similarly to the way, I don't know what you kind of consider that densely shrubbed parts in Forest Park, or even our own Manzanita City Park has an area that's just shrubs. But I also understand that that's not an area for interaction. So I'm struggling. I'm really struggling with that.
If I may, let me comment some more to help you in your struggles. It can't be that a park is any area that's in a unimproved condition. A park is commonly understood as something that is landscaped for the purpose of recreation and enjoyment and contemplation, or something that is left in a natural state, undisturbed. This is neither. That's a disturbed area. And it's not simply the condition that it is in now, it's the configuration. If you look at the design, it's not as wide in some places as a car. It is just, there's no way that you could, through landscaping, turn that into a park. And keep in mind that it's between the pavement of Classic Street and the pavement of the parking lot that would be next to this development, with cars parked right below you. It would be a disservice to the community if we were to accept this application and say it's okay because that's going to be our new park. Public or private, that is not a park.
Is there a definition of park that we can agree to, since we don't have it defined in our code?
Well, when Oregon courts come across undefined terms in a statute or a regulation or an ordinance, they give those terms their plain and ordinary meaning. And they look to dictionaries to be authorities on the plain and ordinary meanings of words. And actually, the courts use one dictionary in particular, Webster's Third New International Dictionary, 2002 edition, revised. It's on the stand to my right. because I use it in my practice all the time. And the first definition there is a tract of land maintained by a city or town as a place of beauty or recreation. I think that's the common understanding of park, whether it be public or private. That just defines who owns it.
Could you read that again, please?
A tract of land maintained by a city or town as a place of beauty or of public recreation. I just cannot get in my head that this narrow strip of land below Classic Street, what I view as the shoulder of the road, the disturbed shoulder of the road, it's not in its state of nature, could ever qualify as a park, thus understood, if this development were built.
Okay. And Frank, would you review the Oregon definition, or was that a definition of hotel? Did you look at a definition for park? Can you unmute yourself?
Well, that was for the hotel.
Okay. Okay.
Yeah, the state itself defines state parks, but I couldn't find anything with regard to private park. But with what Tom says, it would probably be the same standard just based on who owns it, but I'm not sure.
Okay. Well, so I'm just thinking about the plans submitted, assuming that the math calculates properly. It doesn't tell us what it would look like without that little strip of land as far as the percentage goes.
I think the applicant also said last time that it would be contiguous, that it would all be one big space, not chopped up.
Right.
If you're looking at the site plan with the June 6th application, I mean, look at the far left. So the northernmost part of this, right after the driveway, there's a driveway and there is pavement to the right. There are parking spaces to the left. And the applicant includes, as part of the park, like a 2-car length strip in there. That's part of the park.
So let me step backwards just a little bit. And I want to hear from Lee again on this, whether you've had any other reservations, but assuming that we don't have calculations that show what the percentage is in these different areas, I guess that the whole thing can't be considered park contiguously. if we take this, if we deny the application based on this, and the applicant goes back to Luba with it, and Luba says, this looks like a park to us because we don't have a better definition in our zoning code of what a park is, then are we admitting that the density standard is met if this park area is if our my mind is just going blank. If we deny the application based on this 40% doesn't look like a park, and Luba says it looks like a park, or we don't have a definition of a park, and therefore we have to, it goes back to us. Are we saying then that the density standard is met if this is a park? Does that make sense?
Yes, because you would have to present an argument against the density standard for that to go along with the same question about whether or not it's a park. I think what you're saying is that would they assume then we are okay with that, but yeah, but that hasn't been signed off on yet. So I see what you're, yeah.
Okay, so I want to make sure that we address the density standard as well.
Right.
Assuming, and that's the 4.030, whatever, 3.030. So Lee, what's your thinking? Has it changed at all?
Yeah, I'm more inclined to lean with Tom on his thoughts regarding the space not meeting the standard definition or what we think of as a park. But if we could back up just a little bit, we're talking about the density standard and the exclusion based on the fact that these are dwelling units. And if they're classified as dwelling units, then in order to get to 13 units per acre, we have to have the 40% open or park space. Excuse me, I keep misrepresenting that. I'd like to go back a little bit and talk about whether they're dwelling units or not. The fact that the zoning code says that if you have 4 or more of the particular features, i.e. sink and toilet and cooking facility, that it's a dwelling unit. And I think that interpretation, that definition was actually created to determine whether or not a building met the standards for a dwelling unit, i.e. a garage is not a dwelling unit. I've stayed in resort communities that were referred to as hotels, and they had 3 bedrooms and 3 bathrooms, and they were detached. They weren't residences, they were part of a hotel. So I'm throwing that out as can we go back to not using the dwelling unit as a definition for these buildings, but rather the original application, which was a hotel. So I'd be happy to discuss that.
Okay, carry on.
Oh,
Are they dwelling units?
I don't think they are, based on my knowledge of the Oregon State Building Code. They could be, but a lot of times what is in the building code is what somebody says it is. And here's a perfect example of that. Now, does a dwelling unit have to meet certain standards? Yes. And as I pointed out, there are elements within the building that would say that it either meets or doesn't meet the criteria for a dwelling unit. But the fact that it has those fixtures and implements in place doesn't automatically make it a dwelling unit. Again, that information is in the zoning ordinance based on the building code and taken out of the building code for purposes of determining what makes a building a residence or a dwelling unit. But it doesn't have to be a dwelling unit in order to be lived in as an aggregate number of buildings used for housing transient lodging.
Okay. Anybody else want to comment on the dwelling unit? I don't think we have enough information on some of these units to determine whether or not they're dwelling units. But I think I would agree with you, Lee, that that these are not intended to be dwellings or long-term use. They're intended to be transient lodging. And we have a hotel operating in our city. Right now we have several of them that meet 4 of the items that we're calling dwelling units. And we are not considering those as dwelling units. I think we have to look at this project in the whole, as a whole. And if we consider these dwelling units, then I think that if doing my own math gets us to 29 dwellings total, not 13. But I personally don't see these as that. I don't think we can apply the dwelling unit standard. It's a development, an overall development intended for transient lodging. And I don't think we can look at them as dwelling units.
I think part of the problem is that the other hotels that are being referenced have been here for so long before short-term rentals were ever an issue. And so I think the city failed its citizens going forward by not declaring exactly what is what. And this is going to continue to be a problem until the city recognizes this and makes amendments and makes changes in zoning to specify exactly what is what. The Highlands, if I bought up the rest of the property in the Highlands and over by the transit station and decided to do the exact same thing, is the city okay with all of that being developed into what is basically circumventing the short-term rental issue of building and calling it a hotel, meeting all the hotel standards, but basically building homes that are rented like Airbnbs, because that's what's happening. And listen, he does wonderful work. The place is beautiful in Arch Cape, and I'm sure it would be beautiful here. And that's not even the argument. It's whether or not the city is going to define or allow this to continue. Because if it does make no stand anywhere, then there's nothing that we would be able to do to stop this from continuing. And if the problem is that there's not enough housing and there's already too many short-term rentals, And these kind of projects are allowed to continue, because once this one's allowed, how do you stop the next one if everything's based on this criteria? So I can go over, buy the next big chunk of land, put 40 buildings on it that are all basically single family homes, call it a hotel, meet all the regulations that are currently needed to be met, and just circumvent the fact that I didn't just build single family homes and renting them out. I'm calling it a hotel because I'm grouping them all together. So I think, and that may not pertain to this one, and this horse may have left the barn already, but going forward, this has got to be addressed. This is just not a way to do things.
Yeah, I would agree, but I also think, I think it was Lee that said that we've done a disservice to our citizens by not wrestling with this issue sooner.
No, I agree. I 100% agree.
Yeah. Yeah, go ahead, Tom.
But this code should be cleaned up in a lot of places, including this one. But right now, what's on the table is this application, and it doesn't really matter to me how an interpretation of dwelling unit for these purposes might affect the things that are already built in other zones. I mean, that's meaningless. What we have to do is construe this code as applied to this application. And part of the problem here is that this application, I mean, a dwelling unit is a defined term. It is a one or more rooms. So it can be just one room designed for occupancy. Okay. This application has a bunch of different types of lodging. They're all at least one room. It also has to have 4 or more of the following amenities: refrigeration, cooking facility, or wiring for cooking facility, dishwashing machine, sink, garbage disposal, toilet, shower, or bathtub. Now, for some of the structures, from what I can tell from the application, they are clearly have 4 or more of those amenities. So they're clearly a dwelling unit as defined in our code. Some of the other lodgings, I can't really tell because they haven't given us enough information. But we were relieved of the burden of inquiring about that, or making the applicant tell us exactly what amenities are in each of these lodgings, because they said we will meet the higher density standard. In my view, that's sufficient. We don't need to go back now and find out and determine whether they are dwelling units. They, in effect, waived that by saying we'll meet the higher density standard. If they didn't, then I would go back and say, you got to complete these applications and tell us. I assume in every one of these lodgings, there's going to be a toilet, a shower, a refrigerator, even the hotel-sized refrigerator, a sink. It can't be that someone can submit an application and say, here's a room, I'm not telling you what's going in it, because I don't want to qualify as a dwelling unit. The applicant took that issue off the table when he said, I'll meet the higher density standard. So I would simply apply the standard without determining whether they are dwelling units. If we need to make that determination, I think they're dwelling units based on the information we have, or at least most of them are. And that's sufficient to trigger the density standard.
So do they meet the density standard?
I think they don't meet the density standard, because to do that, they have to get to the 13 dwellings per acre exception. And to get to that exception, they have to have 40% of the lot dedicated as a park, and they can't do that except by including a large area of the lot that, in my view, is not park-like and could never be if this development is built out.
Okay.
So to Karen's concern earlier, then, if that's agreed upon, what you're saying is that if it does go back to LUBA, that we have then conceded on the dwelling issue. Because that's the point that you raised earlier. So if we interpret it that way, as Tom just said, then that part of it has been conceded. It would be whether or not LUBA says, "Oh no, that is a park."
Yeah, I think that's my interpretation, Frank, is that.
Is that right, Tom? Or is it...
Yeah, if LUBA comes back and or the city council before LUBA disagrees with us and says, no, we think what they have called a park, including the shoulder of classic section of this thing, qualifies as a park, then they've met the standard, even if they are dwelling units, and they get a build, unless they don't make some other criteria, but at least they would have satisfied this one. But that's a decision for the city to make after us, and then LUBA to decide whether they agree with it.
Mm-hmm. Yeah, my thinking is that they meet the density standard if this 40% is a park. That's where I'm landing on that. Anybody else have a different opinion? I don't hear any. So I guess, is this a park?
Well, I think that's the argument, though. Is it?
Yeah, that's the question, and that's for us to decide.
Well, I said no, and I still hold to that view after this discussion.
Okay.
I would agree with Tom, and I would say no, based on what we know right now.
Okay.
I would agree with that also.
Okay, Lee?
Can we ask Scott a question?
And can we ask Scott a question?
Yes.
Yeah.
30. Sure. Scott, you alluded to using some software to ascertain the square footage of the park as submitted. And in doing so, did you incorporate that area between the parking lot and Classic?
I included all the dark green. I did not look at the lighter shade green, which, near the micro cabins. And I don't have, it'd be nice if I had the same file Vito did, because I could highlight that and take out sections that weren't, if we remove that portion. And I'm not sure if it'd be appropriate to ask the applicant to show that on his computer taken out, or if he'd be able to do that. But it would take me a few minutes to actually do the calculation.
Yeah, I think that would be new testimony.
I think it might be, but if you want to give me some time, I could go back in, open it up, and highlight just that area, minus which part do you want to take out of it, square footage wise?
Well, I don't know that I want to take anything out. My question to you was, did you incorporate that area between Classic and the parking lot when you determined that it met, I believe you said 44%? Is that right?
The number that he came up with, I believe around 44%, was included all of the dark green on the map that he supplied.
Okay.
Which was from Dorcas Street along Classic all the way down to the south end.
Thank you. Mm-hmm. Thank you. Well, Karen, I'm gonna agree with Tom's assessment, and it sounds like Frank and Phil as well, that area really is not park-like and doesn't meet a reasonable standard for a recreation area, if you will. So I'm going to agree.
Okay. I'm persuaded as well. I think I will agree that that area should not be considered a park, and that we don't have enough information to determine. And I would say not just the little strip, but the area, pretty much everything from the parking area adjacent to what they're calling the hotel cabins, that steep slope area. I don't think we have enough information based on the topography. We don't have topographical information on this. Whether the 40% standard can be met.
And as the applicant said, 40% would be contiguous.
Mm-hmm.
I think that's important because they stated that at the last meeting.
Yeah, that little bit that crosses the pavement. I don't think taking that little bit out would affect the overall characteristic. So I'm not too worried about that little piece sticking out there that's not contiguous. But okay. As far as the walking path goes, the applicant said it's probably not appropriate for bicycles. What their expectation of how that path will be developed or maintained. There was that one outstanding issue related to the traffic, and that whether this walking path as proposed would alleviate some of the traffic issues or traffic concerns on Classic.
Erin, before we get to the traffic issue, would it be possible to take a short break? We've been at this about 2.5 hours, and I may have drank too much coffee this morning.
No problem. Let's take it 10 minutes. Is that enough? Adequate?
Yeah, that's plenty.
Okay. It's 12:12 according to my computer, so we'll see you at 12:22.
Thank you.
Mm-hmm.
This is Esther Frank in regards to Wanda Cafe and Great Heights. This is Hope with Oldsco, and I'm calling in regards to
Okay, it's 12:22. Are we all back in place, ready to go again? It seems to me that the one outstanding issue that we have is whether the question about whether the streets are adequate to support the anticipated traffic and development will not overload the streets outside the planned area. We made a preliminary determination that this criterion was met if the proposed trail through the site could provide safe access for pedestrians and bicyclists. And I want to reopen the discussion on that point. Does the proposed trail through the site provide safe access for pedestrians and bicyclists? And if so, is the criterion met? Go ahead, Tom.
Okay. Well, first of all, I thought I heard them say today that it's not going to provide any access for bicyclists. It's just going to be a pedestrian walkway.
Does that alleviate enough? I guess the question is does that alleviate enough of the traffic question on, on Classic? And my thought is that that the trail would provide additional safety for pedestrians if it's walkable and maintained as a walkable trail. I think I would agree with the applicant that bicyclists would probably use Classic anyway.
Well, my if I may, my thinking on this has evolved some. I don't think that the pathway the applicant is proposing is an appropriate solution to overloading of Classic Street by the added traffic from the development. Because what you're doing is you're making pedestrians leave the Classic Street and take an alternative route down a steep incline with switchbacks, perhaps, or maybe probably, then back up, and then it deposits them in a parking lot where they're going to have to deal with movements of cars in and out of a parking lot, and then empties them not where they would have been before at the intersection of Dorcas and Classic, but at a driveway where they will have to be dealing with cars coming and going. So I imagine for people that are walking down Classic Street that, to and from the Classic Street cottages, ordinarily they would be walking on the right side of the street, heading northbound, and would turn immediately into the driveway to their home. Now they're going to be diverted down a hill, through switchbacks, back up again, through the parking lot of this development to come out at the driveway to this development, where they will now have to turn right, where there is no sidewalk, go up to the intersection, cross the intersection to get where they otherwise would have if they'd have taken the direct route. I don't think that is an acceptable solution to any overloading of Classic Street from traffic from this development. To basically say that some of the people now entitled to use that street as a pedestrian or a bicyclist, you need to take some other route, circuitous route. They would want to stay on Classic Street because it's shorter and it's level, and that's their accustomed mode of transportation there. And it doesn't seem right to me that we're going to approve a development because, well, you now have to go a different way than what you have been.
I believe that the transportation study that was provided, I don't recall it identifying the additional traffic on Classic and into that intersection would have a negative impact or a significant negative impact on pedestrians. And I'm not sure that it's, that the applicant offered to put the trail through to accommodate pedestrians, but I don't think the onus should be on the applicant to alleviate all, to require. I don't think pedestrians should be required to follow that trail. It's available for those who want to get off of Classic. I think that's my thinking on that it shouldn't be up to the applicant to solve the pedestrian problem if the traffic study doesn't show that it increases the traffic problem. And I don't believe that the traffic study.
Here's how I interpret the evidence is that their study says there will be 309 daily trips at most. The applicant said that works out to one every 2.5 minutes on average, one additional trip. But of course, it's not going to be one car every 2.5 minutes. It's going to be concentrated at particular times. I assume mostly at checkout time and check-in time for the hotel. Just like traffic in Portland is concentrated at rush hour, morning and evening. There'll probably also be a lot more traffic. Those 309 trips, a lot of them will be 8 to 9 in the morning when they're going to Frank's Place for breakfast, or 5 to 7 at night when they're going downtown for dinner. So it will be concentrated at certain times. But it's 309 additional trips, even by the applicant's evidence. And the issue is not so much how many trips are added, but is the system overloaded already? You can add just a bucket of water to the bathtub, but if it's already full, the bucket of water is too much. I'm persuaded by the evidence from the people who live in the area and testify about driving, walking, and biking on those streets that it's already too crowded to accommodate all forms of transportation. And an even more, for me, telling piece of evidence is the city's transportation plan. The city's already concluded that when they have the money, they should widen that street to have a dedicated place for bicyclists and pedestrians. So that's, to me, some evidence from the city that the roads are already overloaded. So adding more traffic via this development would overload, in my view, overload further, I guess, the adjoining streets. And the solution that's being proposed to that added burden is to encourage, the people that are using it now as pedestrians, at least, to go another way. I don't think that's the proper solution.
And I think to your point, Tom, I also don't know that people would be even familiar that there's a trail down there. Like, how would they even know that thing exists if they're just used to, using Classic Street, unless it's clearly marked and there's big signs that says, hey, trail, pedestrian trail. And to your take on between 4 and 7, you think about that, that's check-in time is 4 o'clock. So there would be a concentration of traffic then. And then you're right, because then once they get checked in, okay, now let's go out. That's typically what happens. So in that block, that afternoon block, it would be very busy. And then checking out by 11 o'clock, that might be a little bit more staggered because some people will leave earlier than others, but point well made.
Plus, if you look at their site plan, they've got the pedestrian trail going through 2 spaces of parked cars. Who's gonna? That's just not acceptable as an alternative to what should happen, and I don't understand wasn't required. It is they build the pedestrian bike pathway up on Classic Street as part of the development. What this alternative doesn't solve the problem. And again, I don't think it's right to tell people that, well, we're going to approve this development, and so now you don't get a walk along this street the way you once did. Or, I mean, our solution is to try and move you off it. So I guess what I'm saying overall is I don't think this application satisfies criteria 4.136 C5.
I'm going to respectfully disagree. I'm going to rely on the information submitted by the city's traffic engineer, contract traffic engineer. I believe that's the right designation. That he's reviewed the transportation impact analysis provided by the applicant, and that I'm going to agree with the staff report that says that staff found that the transportation impact study for Manzanita Loft submitted May 4th, 2023 complies with the scoping letter provided to the applicant and demonstrates that impacts from the project will be minor, with all study area intersections operating acceptably with the project in place. I see the trail as if it's posted as described and maintained, built and maintained as described, as an alternative for people to get out of traffic, but not a requirement that they use it or do so. So I'm going to respectfully disagree and stick with the preliminary determination that the criterion is met. Phil or Lee, would you like to?
Sure. Yeah, Karen, I agree with you. I'm not a traffic engineer. I have no idea how these things work. Tom brings up some reasonable points about the 309 cars per day trips, being packed into certain times of the day. But I don't think that I have enough knowledge nor background to be able to say that that what they've proposed isn't reasonable. And again, the trail is, as you point out, Karen, the trail is not mandatory. It might only be used by 2 people a day, but that's 2 less people per day on Classic. So I agree that the criteria was met.
Okay. Bill, do you want to comment?
I agree that the criteria was met.
And It came a little garbled. You agree that the criterion is met?
Yes, correct.
Thank you. Further discussion?
Madam Chair, I just wanted to bring one point to you, which I think relates to both of these issues, is that the question before you is first whether the proposed use meets the criteria as it is. But there's also a question of whether it can meet the criteria with conditions of approval. So, for instance, whether whether the signage might be an item that you add, or if the open space could be configured differently on the property, that's also something that you can consider.
Is it the burden on the commission to redesign a project in order to meet that standard? It seems to me we can only work with the material that's presented to us.
Yes, but I think that I think you may have an option to impose it as a condition of approval that it meets certain requirements. So the open space meet certain requirements in a different configuration. Of course, you wouldn't know what that configuration would be without gathering additional evidence, or what those configurations could be without gathering additional evidence.
Well, let me speak to that. There is no way that I think that this commission can tell the applicant how to reconfigure the park on this property. I, for one, I'm not sure it's capable of doing that. But I mean, if you're suggesting that we can approve something and just say, meet all the requirements for approval, then what are we doing here? Okay, so we take the application as presented, and I'm okay adding something like, if you have a bike path, please put up a sign there. But just saying we're going to approve this thing and make sure that it meets all the criteria, then this is a waste of time. They have to present a plan that meets the criteria as presented. And at least as far as the open space, I don't think they do that. As far as the traffic requirement, I don't think they do that either, but it looks like 3 commissioners at least disagree. I don't know where Frank stands. But it can't simply be, we approve this application and just make sure you don't overload traffic on adjoining roads. Or please make sure you put in 40% as a park somewhere and call that good. That's our job, to find out whether the application as presented meets it.
And I think going to the traffic study, they provide us with a great number of data points, but it's our job to interpret what those data points actually mean in reality. And when we were talking about whether or not there's, we're going to get hammered between 4 and 7 p.m. with all these cars checking into 40 units with multiple people and multiple cars unloading their vehicles and then going downtown, that traffic study doesn't take any of that into consideration. They give you data points. They give you numbers. They give you gross numbers. They don't know, those hours. They probably didn't even take into consideration what the check-in times were, because that's not what they do. They just give you data points. It's our job to take that data and information and then understand how it works in the real world.
And what's your thought on that?
Well, I agree with Tom. I mean, that's why I made the points earlier. If you think at 4 o'clock, 5 o'clock on a weekend, when there's all those people checking in all those units, and they don't all come in one car, there's going to be, I mean, just think about what that's going to look like. Think about what it looks like on a busy weekend period without that construction being there. Now add all those units, all those vehicles, and you have to take, we have to take that into consideration. Yes, the data points say 309 trips. Well, every 2.5 minutes. Again, like Tom said, those are averages, and that's whatever those the engineering studies come up with, but that's not reality. We know that. You don't even have to be a traffic engineer to know that. I know the ebbs and flows of the business and what hours are busier than others, and all of those things just by living here and operating a business. That's just the reality of it. And I think we cannot ignore that, because the traffic study says 2.5 minutes every car will pass. Well, that's great, but that's not realistic.
I just want to be clear on this point, because part of the reason this issue was remanded was that we didn't have information that said that there would be 309 trips per day. That was an estimate based not on a traffic study. So did the traffic study that was done and was reviewed by the city staff say 309 trips? I want to make sure that we rely on the evidence that we have in front of us and not speculation. And I don't remember a number in the city's traffic study that how many additional trips per day, and we should rely on data and not speculation. Just when we refer to that specific number, we were remanded once on that. I don't want to have that part of the record this time without having evidence that supports that number.
Karen, my recollection on that was that the remand, and Savani, you might weigh in here if you recall this as well, that the remand was because we or the council, I don't remember which, used terminology such as more than 309 trips a day, when the traffic study indicated 309. Is that what you recall, Savani?
Yeah, you're right. The reason that LUBA sent this back is because either we or the city council beforehand said more than 309, and there was no evidence of more than 309. But I understand the traffic study and the applicant to say 309 is the number.
Well, that's the number for a peak day in the summer. So it would be up to 309, right. Or at least that's the way that LUBA interpreted the evidence.
And I could speak to, it's in the record if you want me to.
Please.
But the findings were weekday trip generation was estimated based on Land Use Code 320 motel in the IDE generation handbook. Since that Land Use Code does not have data for Saturdays, data was also used from Land Use Code 310 hotel. The TIS, so this is Lancaster's review of the TIS, that site will generate 94 trips over a typical weekday with 19 trips during the weekday peak hour. On a Saturday, a total of 274 trips would be generated with 24 trips during the Saturday peak hour.
Do they define peak hour?
I'd have to call through the report, but it's in there.
Well, one thing that they didn't consider in the report, because it didn't come up when they did that, is, and this adds to Frank's scenario, the people coming in and out at check-in, check-out time. And I don't know if that corresponds to the peak hour, but whatever. Is those cars are going to be moving through the parking lot, pulling out of parking spaces, going to the north end of the property, going out the one driveway, now with pedestrians coming through the same parking lot via the pedestrian walkway. I don't think the traffic study took into account whatever hazards might come about from having pedestrians moving through the parking lot at the same time that the cars are coming in and out.
that they would be moving through the intersection otherwise. So,
Well, it's probably less hazardous for them to be moving through the intersection than moving through the parking lot. All the cars are going in and out of the parking lot. Some are turning left on Dorcas. Not all of them are going right, but if they go right, they stop at the stop sign, and so they will wait for pedestrians. There's no stop signs in the parking lot. You're going to be having people walking through it on that pedestrian walkway in the midst of cars moving in and out. I don't think the traffic study took that into account.
okay. Has anyone been persuaded differently than previous? If not, I'd like to call for a vote on this particular question of whether the criterion is met, the traffic criterion is met. If the proposed trail through the site could provide safe access for pedestrians and bicyclists, that's where we left it. So I think this is the only area that we didn't reach consensus on. Is that correct? So I think we'll call for a vote. And then what I'd like to do is go through the staff report and make sure that we agree with the findings throughout the report, and then make a determination about whether to approve or disapprove this application based on the findings. So let me call quickly for just a vote on this. All in favor of a preliminary, of making it the determination that the traffic criterion is met with the proposed trail through the site, providing safe access for pedestrians and bicyclists. All in favor?
Yes.
That's 2. Okay, all opposed?
Opposed?
Okay. Okay, so this criterion is not met. And I would like to have the basis for that criterion being not met.
Well, I think it's we've been discussing is that the traffic expected to be generated by this development at peak times will overload the existing road, the adjoining roadways, and that problem won't be alleviated by creating a pedestrian walkway that, as depicted on the site map, from Classic through the parking lot.
Okay. Okay, thank you. Okay, let's start back at the beginning of the staff report. I want to go past the summary, past the procedural history, past the procedure on remand, and go to section 4, the provisions at issue. I'm just going to kind of go quickly, if that's okay, and stop me and slow down if we get to a point where we're in disagreement.
Can you say what page, Karen?
Yeah, I'm starting on page 5, section 4, procedure on remand. No, I'm sorry. Plan development unit provisions at issue on remand. The first issue, I believe we don't have much to say about, because is that we can't consider the Manzanita Comprehensive Plan provisions in making a determination on, I can't remember what we call this kind of a determination, but it's not a broad brush determination, but a specific one. That we need to make our findings based on the zoning ordinance provisions without reference to the comprehensive plan provisions. That's basically where the LUBA has told us that's the line in the sand. Section B addresses the density standards under Manzanita zoning ordinance 3.0304 and 3.0304A. And the density standard, and LUBA has accepted that the proposed use is a hotel and is I guess the determination. The city's ordinance does not define hotel. Let's see, let's get to the findings here. So now I'm on page 7, the top of the page, findings. The question is, the Planning Commission can determine that the density standard is met or can be met with a condition of approval without making a determination about whether some or all of the hotel units are dwelling units, or whether the density standard applies to the proposed use. We requested additional information about the proposed open space, left the hearing open. And the question here is, well, that moves on to the next question.
Well, I think that the finding that I thought the consensus was is that the applicant had not met that criteria because the proposed open spaces park doesn't meet the 40% requirement of the total area.
Okay, I believe that's correct. I think that I just want to go back and make sure that we hit all of the findings. There was a question that we settled, I believe settled earlier, with at least a preliminary finding, that the resulting development will not be inconsistent with the zoning objections of the area. And I believe we agreed that the that section is forward-looking, in that this development won't hinder future development that is inconsistent with the zoning ordinance. We also made a preliminary determination that stormwater runoff, that's another section, could be managed on site, that the applicant will follow this procedures for that. Okay. And so we've just made a determination that the streets are inadequate to support the anticipated traffic, and development will overload the streets outside the planned area. And that the that issue will not be alleviated by the walking path as depicted. Sorry about that. Am I correct?
Yeah, yes.
Lee, you're muted. Did you say something?
Can you please repeat that, because I think you just spoke opposite of what we had determined regarding the traffic. At least I heard it differently.
What I wrote down was the Planning Commission determines that this criterion is not met as far that the streets, the criterion is the streets are adequate to support the anticipated traffic, and development will not overload the streets outside the planned area. And it looks like our determination is that that criterion is not met, that the traffic generated will overload the adjoining roadways and will not be alleviated by a walkway as depicted.
Maybe I misunderstood the vote. I thought the vote was 3-2. But does it have to be unanimous?
No.
Okay. Well, I guess I'm not getting it. Can someone help me?
Well, it was you and Karen that voted the 2, and I believe it was Phil, Tom, and myself that voted against. So that's what Karen is relating.
I'm sorry. I thought Phil had voted with Karen and I, so.
Oh, I'm sorry. And unless I got that wrong, then Phil, would you clarify?
Yeah, I changed my vote based on the testimony that was given.
Thank you. Thank you all for the clarification.
Okay.
Yes. So it's down to those 2 points, the traffic issue that you just mentioned, and then also the density issue with the regards to the 40% of whether or not they've met that.
Mm-hmm. And at this moment, it sounds like the consensus is the applicant has not met the criteria for approval based on those 2 items. Am I correct?
I agree.
Do we need a formal motion to accept or deny the application?
Yeah.
If so, I move that the application be denied for the reasons we've just discussed.
I would second.
Okay, I want to add just a little bit of further discussion. As far as the recommendations, conditions for approval, do we want to go through those before we vote on denying or approving the application, in the event that council, this goes to council, because they may want us to chime in on, they may change what we do here.
I don't know what, this is my first rodeo, so I don't know what the custom is, but it seems to me when this goes to the city council, if they're going to do something different for whatever reason, then they should be the ones that come up. I mean, if they're going to reject our decision and approve the application, for whatever reasons, they should be the one that attach conditions to them. I don't think that we should sit here and go through all the hypothetical conditions based upon their decision, whatever it is. But Layla will correct me if that's the usual practice.
Well, we haven't run into this before, frankly. So I think we can make a decision as we see fit.
That would seem to be quite an undertaking to sit here and try and go, okay, if they vote this way at the city council, then here's the conditions we'd attach. I mean,
okay.
If they might disagree with our conclusion about traffic, so all of our conditions about traffic would be moot. So I guess I would just let them do it, or if they don't want to do it, they could send it back to us. I mean, if they say we approve it, they could send it to us to do conditions of approval with some direction.
Yeah, I don't know that it would come back to us after we bounce it to the city, assuming that the applicant appeals to the city.
Okay, then I
think the city's determination is final.
Okay.
Okay. Well, it's been moved and seconded to deny the application based on the criteria as stated. Is there any further discussion? Hearing none, I'll call for a vote. All in favor, say aye.
Aye.
Aye. Any opposed? Okay, the motion carries. Okay, that's the end of our business here today.
And I would just say that I would agree with Tom that it is, we've followed our process. The city council now follows their process, and they take it from there.
Okay. I want to just go on record before we adjourn and say thank you very much for your considered, thoughtful responses to this application, both to the commission members. It's a lot. It's a big burden to take on, and I want to acknowledge that you've done very well with this. And I also want to thank the citizens of Manzanita for helping guide us in this decision.
Well, and Karen, we all want to thank you for chairing these meetings so well and leading us through.
I appreciate any changes of direction that I need to take. So
none needed.
Keep us going honest. Okay. If there's no further business, I'll adjourn the meeting. Okay, we're adjourned.